Hello guys, welcome back. Today I'll be sharing with you the interesting origin of common law and equity. And I hope at the end of the video you'll be able to write a well-articulated essay on the origin of common law and equity. With the help of my video and personal study, this will be possible. Because with God, all things are possible. Common law is a division of law, and it was received from England alongside with equity and statute of general application. However, the growth and origin of common law can be traced to the period before the Norman conquest of 1066 AD. Now, common law developed from the old common courts of England, which consist of the King's Bench, the Court of Common Pleas, and the Court of Exchequer. Now, before the Norman conquest of 1066 AD, there were different laws operating in England, in different regions of England. Every locality had their own laws, their traditions, and their customs in operation. During that period, usually the king would send out judges, royal judges, to administer justice. Now, these royal judges that were sent out usually administer justice in accordance to the local custom of the people that was in operation. So if the custom of a particular area says that murder is punishable by death, when the judge is going there to administer justice, he would walk and give judgment in accordance with that law. So this continued, and each time they go out on tour, they come back and converge at the Westminster. So at the Westminster, the different judges sent out would usually come together and compare and analyze, pick out the logical customs and tradition and the illogical ones. And so when they go out on tour again and they come across a case where the custom of another land or another region seems more logical, usually they disregard the custom of that locality and go for the more logical law. And soon, in no time, they began to disregard the customs and tradition of the local people and go for customs and tradition of other regions that seemed logical. And slowly and steady, the unified system of law was developed, and this was the common law of the realm. So this common law became unified and was in operation in all areas of England. So it was the common law that was applicable in all areas of England. Different regions no longer had their own operating system or own operating law. There was a unified law that was established as a result of the different customs that the judges came across in their different tours. So this was the beginning or the growth of common law. So common law judges made law. They are laws that were made by judges from previously decided cases. And this was how common law was formed. However, common law was so strict. Before you can file a case, in the common law, your case must come under a particular writ. Filing of action in common law started with the issuing of writ. So if your case did not come under a particular writ, then there's no remedy. Even when you file your case and your case is able to come under a particular writ, you may not get an effective remedy. Common law was so harsh. It was strict application of the law, irrespective of circumstances of the case. So if murder is 3 years, in common law, you will be punished 3 years without caring if the accused was insane, or if he was provoked, or if it was done out of mistake, or if it was done out of self-defense. It was the strict application of the law. It was so harsh and strict. Now, common law was so strict, it had so much injustice, and because of the injustice that would happen during the common law, people started writing petitions to the king to use his veto power. Now, it was the chancellor, the king's prime minister, that handled and dealt with all these petitions. He would attend to the matters raised in the petitions, and before long, people started writing petitions directly to him without having the king's name on the petition. So he began to try cases on his own without involving the king and making decisions. In fact, decrees were made in his name. That was the beginning of the equitable jurisdiction of the Court of Chancery. Judges passed judgments that was not in favor of the people, they began to direct petitions to the Court of Chancery, and the Court of Chancery would use his equitable jurisdiction to revoke most of the judgments of the common law judges, and this caused a friction between the common law judges and the Chancellor. The common law judges felt the Chancellor was frustrating their efforts, and this conflict continued not until it became opened in the case, the Earl of Oxford case. Now, in this case, the defendant leased the plaintiff a piece of land. However, the plaintiff built a house and planted some flowers in the garden on this leased piece of land. The defendant forcefully ejected the plaintiff out of the land, and he took his case to the common law. In the common law, judgment was given in favor of the defendant, and so the plaintiff wrote petition to the Chancellor. He prayed that the Chancellor should restrain the defendant from ejecting him from the house he built on the leased land, and truly the Chancellor granted the injunction. So this case led to an open war between the common law judges and the Chancellor, and the Chief Justice of the King's Bench by the name Coke protested that the Chancellor was frustrating the effort of the common law, because it seems like the Court of Chancery was becoming a court of final say, in the sense that litigants that were not satisfied with the decision of the common law courts could actually write petitions and bring their case to the Court of Chancery and have the decision of the common law judges revoked. It was frustrating to the common law judges, especially the Chief Justice of the King's Bench, Coke. However, the Chancellor, Lord Ellesmere, claimed that he wasn't frustrating the doctrine of common law. Reasons being that, looking at the case, it was obvious that the decision should be given in favor of the plaintiff. For whoever builds a land, builds a house, should live in it. And when the case came on to the Attorney General, Lord Bacon gave judgment in favor of equity, and there he stated that where there was a clash between equity and common law, equity should prevail. Now, the fact that both systems refused to operate in one court did not erase the difference and distinction between two. There's a difference between a legal right and an equitable right. A legal right is a right that is enforceable on strict provisions of the law. So, for instance, I and my best friend have a signed agreement that I will sell a bag to her. Now, I have two bags, a black bag and a white bag. Now, my intention is to sell to her the white bag, but her intention is to actually buy the black bag. Now, there's a confusion between two of us because she actually doesn't know which of the bag I want to sell. If, peradventure, after paying me the 25,000 naira, I deliver to her the white bag, when she actually wants the black bag, there will be friction between both of us. The case is taken to common law. The decision would be that since there was a signed agreement that I would sell a bag to her for 25,000 naira, she has to accept the bag that I want to give her, irrespective of the fact that there was a mistake or misunderstanding or an element of mistake, in the contract. So she has no choice to rescind the agreements. There will be nothing like that. That's a strict application of provision of law, common law. But in equity, the circumstance of the case will be critically observed. If by reason of observation of the case it is discovered that there is a misunderstanding or a mistake, then the contract can be rescinded because we both never had the same subject matter in mind for the contract. I had the white bag as the subject matter of to be sold, while she had the black bag as subject matter in her hand that she would buy. So this can make the contract rescinded. So you can see that equity most times deals with fairness. Equity is just, but common law is strict, harsh. However, the Nigerian court and judges try to find a balance between both to ensure that justice is administered. For further clarification, you can see chapter 4 of Abiola Sani's introduction to legal method. And I hope that this video has enlightened you, and with your personal study, you'll be able to write a well-articulated essay on the origin of common law. I hope to catch you once again in my next video. Please subscribe, like and share, and write reviews, make contributions. Tell me what you think I should do to serve you better, and hopefully we will get better with time. Thank you.